Courts used to treat gun laws like they were carved in stone, but this past year flipped the whole script in a way nobody was ready for. Judges are tossing out regulations that survived for decades, and it's happening so fast that even the states pushing these laws are getting whiplash. I'm Scott from Line 45, and I'm laying out the 7 real courtroom hits that are tearing down old gun laws right now so you know exactly what's changing and what states can't get away with anymore. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. Alright, enough of that. Let's get back to it. Nobody saw this courtroom shift. When I look at gun cases now, the first thing that jumps out at me is how judges completely changed the rules of the game after the Bruen decision in 2022. Before that, courts usually gave gun laws a lot of slack, as long as the state yelled public safety and could show some kind of data. Now, the Supreme Court basically told them, you start with the text of the Second Amendment, and then you check if there is a real historical tradition from around the founding or Reconstruction that looks like this modern law. If the state cannot bring receipts from history, that law is in trouble, no cap. You can see the shift in the kinds of cases that are winning. Federal courts have tossed or seriously questioned things like total public carry bans, overbroad sensitive place designations, some age-based bans, and even possession rules that used to be treated as automatic. Judges are writing long opinions about gun regulations from the 1700s and 1800s, and they are openly saying, this modern restriction does not line up with what Americans actually did back then. That is a huge change in tone from the pre-Bruen era. At the same time, the Supreme Court reminded everyone in the Rahimi case that this new test does not mean every gun law dies. They upheld taking guns away from people under certain domestic violence restraining orders, using the history of disarming clearly dangerous individuals as the hook. So, the new vibe is pretty simple. Courts still allow some targeted restrictions, but broad, lazy gun control with no real historical support is getting smoked in opinion after opinion. Sensitive places laws are getting shredded. On the whole sensitive places fight, I keep seeing states try the same move, and judges are over it. After Bruen, New York, New Jersey, Hawaii, and a few others acted as if they could just slap the sensitive label on half the map and call it constitutional. They tried banning carry in parks, beaches, restaurants that serve alcohol, most private businesses, and even whole chunks of downtown. Courts started looking at that and saying, Bruen literally warned against turning entire cities into gun-free zones, so some of these lists are getting chopped up, no cap. New York's CCIA is a good example. A federal judge in Antonyuk hit big parts of the sensitive places list, and the default ban on carry on private property opened to the public because the state could not tie them to any real historical tradition. The Second Circuit later let more of the law stand, but that private property default rule in some locations are still under heavy attack, and the case keeps getting kicked back toward the Supreme Court. New Jersey ran the same play with a long list of no-carry zones and a rule that made all public-facing private property off-limits unless the owner posted consent. The trial court in Coons blocked a bunch of that as likely unconstitutional under Bruen, especially the private property default and vehicle carry piece. The Third Circuit later saved most of the sensitive place list, but let the hit on the insurance mandate stand and flagged that these blanket bans cannot be created by pure government fiat. Hawaii is now in the hot seat in Wolford, where federal judges have already said you cannot just declare almost every public space sensitive and pretend the Second Amendment still means anything. Age-based gun bans are falling apart. On the age bans, this is where I feel like a lot of states got caught slipping. For years, lawmakers treated 18 to 20-year-olds like second-class adults when it came to guns, even though that same group can vote, sign contracts, and go die in a war. After Bruen, a bunch of courts started asking a simple question. Where is the historical tradition of banning that age group from owning or carrying common arms? In a lot of these cases, the states just do not have the receipts, no cap. You can see it in real rulings. The Fifth Circuit in Reese went after the federal under 2-1 handgun purchase rule. The court pointed out that at the founding, militia laws literally assumed 8-year-olds would show up with their own privately owned firearms, so treating them as too immature to buy a gun made no historical sense. Other district courts have said similar things about state carry permit age floors when states try to push the minimum to 21 for everyone instead of tying restrictions to specific criminal behavior or mental health adjudications. Now, it is not a clean sweep for young adults. Some courts are still upholding limited restrictions, especially where the state can show a tight fit with long-standing categories like dangerous or criminally high-risk groups. But the old default, where lawmakers casually throw 18 to 20-year-olds under the bus, is getting hammered. The trend line is simple. If the government wants to block a legal adult from buying or carrying a normal rifle or handgun, they need real historical analogs, not vibes, not talking points, and not cherry-picked crime stats. Serial number and possession paperwork laws are under fire. Serial number rules are where you really see how fragile some of these gun laws are, once courts start asking for history. When I read the Bruen-driven cases, what jumps out is how many judges admit that serial numbers are a 20th century thing, not a founding-era tradition. That is exactly why a district judge in West Virginia, in the Price case, originally tossed a charge under 18 U.S.C. 922, subsection K, the federal law that makes it a felony to possess a gun with an obliterated serial number. The court said the government could not point to any historical practice of jailing someone just because a lawful type of firearm had its markings altered. So, under Bruen, the statute failed. Now, to be fair, higher courts are pushing back. The Fourth Circuit later reversed that ruling and said 922, subsection K can stand, and other circuits have refused to strike it down too. So I am not telling you 922, subsection K, is dead. The point is different. Before Bruen, nobody thought that the law was even vulnerable. After Bruen, the government is spending serious time and money writing long briefs to defend it with history, and judges are splitting on the answer. That alone tells you how much the ground moved under these paperwork and possession rules. Ghost gun and frame or receiver fights show the same tension. In Vanderstock, the Fifth Circuit said ATF went too far by treating a wide range of unfinished parts and kits as full firearms that needed serial numbers and 4,473 checks. Then the Supreme Court stepped in and let most of that rule stay in effect while the case continues. So you have one powerful appeals court saying ATF stretched the statute, and the High Court saying the rule can run for now. For gun owners, that means anything tied to markings, numbers, or definitions is getting tested instead of automatically rubber-stamped. The ATF lost its old superpowers. One thing that stood out to me this year is how fast agencies started losing ground once the Supreme Court dumped Chevron. For almost 40 years, Chevron let federal agencies stretch vague statutes and call it reasonable interpretation. ATF used that to reshape gun laws without Congress ever passing new text. When the court shut that down in 2024, the whole enforcement style shifted. Courts now read the statute first and tell the agency to sit down if the words do not back them up. No cap. You can see the impact in the big fights. The pistol brace rule got slapped around in multiple courts because ATF tried turning millions of braced pistols into unregistered SBRs off a regulation instead of a statute. Judges said the agency had no authority to rewrite definitions that Congress never touched. The Fifth Circuit's Vanderstock ruling did the same thing with the 2022 frames and receivers rule, saying ATF pushed the term firearm way past what the law actually says. Even though the Supreme Court later kept the rule alive while the case continues, the message is clear. Agencies do not get automatic respect anymore. ATF's zero-tolerance push on FFLs also hit resistance. Courts have been warning the agency that shutting down dealers for clerical errors goes beyond the Gun Control Act's language. The old Chevron mindset let ATF claim broad discretion. Without Chevron, courts expect solid statutory grounding for every penalty and every enforcement step. For gun owners and dealers, that means a lot of the ATF's old shortcuts are disappearing, and judges are demanding real legal authority instead of agency creativity. What are the courts killing these days? Permit fights are where I really see courts putting handcuffs on the games states used to play. After Bruen, the Supreme Court basically told New York and the other may-issue states, you cannot make people beg for a permit with some vague, good cause standard or open-ended discretion. Kavanaugh even spelled it out. You can have a licensing system, but it has to look like a normal shall issue setup with objective rules, not a vibes test that lets a sheriff or a judge stall you forever or price you out with stupid fees. New York tried to patch that by swapping proper cause for good moral character and layering on social media checks, reference letters, and deep dives into your personal life. Federal courts have already taken a knife to parts of that scheme, and when the Supreme Court let most of the law ride for now, they still left pieces like the social media rule and the private property default in trouble. The core problem is simple. If your standard is so subjective that an official can always find a reason to say no, that is exactly what Bruen warned about. No cap. New Jersey shows the same pattern in money and delays. In Coons, the Third Circuit blocked the first-in-the-nation liability insurance mandate, a chunk of the fee hike, and a default rule that treated almost all businesses as gun-free unless they opted in. The court basically said you cannot bolt weird costs and choke points onto the permit process just to choke off carry in practice. That is the new reality. If a state uses good moral character, fees, wait times, or paperwork games to turn shall issue into maybe someday, federal judges are a lot more willing to smack that down than they were 5 years ago. How this avalanche affects every gun owner. Looking at the big picture, I treat all these cases as a long game, not a one-off win. Bruen, Rahimi, the bump stock ruling in Cargill, and killing Chevron all push the courts toward one basic rule. If the government wants to keep an old gun law or pass a new one, it has to plug into the actual text of the Second Amendment and a real historical pattern. If that history is missing or weak, the law is exposed. No cap. For me, the country is starting to split into two legal zones. You have circuits like the Second and parts of the Third trying to salvage as much gun control as they can under the analogy language from Bruen and Rahimi. Then you have the Fifth Circuit and some district courts in the Midwest reading Bruen in a much tighter way and knocking out age bans, sensitive place expansions, and aggressive ATF rules. That tension almost guarantees more Supreme Court trips over the next few years. For regular gun owners, the takeaway is simple. A lot of what used to sound settled is not settled anymore. Carry rules, permit systems, certain disqualifier categories, serial number laws, ghost gun rules, and even how far ATF can go with dealer enforcement are all now being tested instead of rubber-stamped. So when I say courts are gutting old gun laws, I am not telling you everything vanished overnight. I am telling you the default setting flipped in your favor, and any restriction that cannot survive a hard history check is living on borrowed time.